When you picture justice, what comes to mind? Probably a courtroom, right? With lawyers and a judge wearing robes. But what happens when that whole system starts to grind to a halt? Well, today, we're diving into something called Alternative Dispute Resolution, or ADR. We're going to explore how this very different approach is becoming absolutely essential for getting faster, more efficient justice right here in India.
This little exchange, it perfectly nails a fundamental challenge in a lot of legal systems. See, the goal isn't always about uncovering the absolute, capital T, truth. It's often about one side winning based on the evidence they can present. And that built-in conflict, well, it really sets the stage for why we desperately need to look at other ways of finding a resolution.
So this tension between finding the truth and just weighing the evidence isn't an accident. It's actually baked right into the design of a country's legal system. Around the world, there are really two main models, and understanding how they work is the key to seeing why ADR is becoming such a big deal.
Okay, so on one side, you have the adversarial system. This is what's used in India, the UK, and the US. Think of it like a contest. The two opposing sides are in the driver's seat, each gathering their own evidence, with their lawyers making the arguments. The judge? They're more like a neutral referee, just there to make sure everyone follows the rules. Then you've got the inquisitorial system, which is common across continental Europe. In this model, the judge is way more hands-on. They're an active investigator, leading the charge to uncover the facts of the case.
Now, the adversarial system is kind of a double-edged sword. On the plus side, that back-and-forth cross-examination can be an amazing tool for poking holes in a weak story, and the parties definitely have more control over their own case. But, and this is a big but, the downsides are huge. Justice can get incredibly expensive, which gives a massive advantage to whoever has more money. And all the rigid procedures, they often lead to massive, frustrating delays.
And just to be clear, the inquisitorial system isn't some perfect solution either. It has its own set of trade-offs. Sure, it can be more efficient, and it can level the playing field financially. But there's always the risk that the judge, by acting as the main investigator, might start to lean one way or another and lose their neutrality. It's just a different set of challenges.
All right, so let's shift from all this theory to the hard reality of what's happening on the ground in India. Because when you take that adversarial model and put it under immense pressure, you start to see some really serious cracks appear.
What's happening in Indian courts today is pretty much a perfect storm. We just don't have enough courts or judges for a country of this size. At the same time, the number of new cases being filed is always going up. Legal battles are getting insanely expensive, and the delays, my gosh, the delays. Cases can get stuck in the system for years, even decades. This is the exact problem that ADR is designed to fix.
But here's the really fascinating part. ADR isn't some radical, newfangled invention. It's actually a return to a much older and more traditional way of sorting out disputes here in India.
So, what exactly is alternative dispute resolution? Well, you can think of it as a whole toolkit of methods, things like mediation, conciliation, and arbitration, that are all about settling disputes outside of a courtroom battle. The key phrase here is non-adversarial. It's about getting people to collaborate and find a solution together, not just about one person winning and the other losing.
And the history behind this is just incredible. Long before we had modern courts, India had its own forms of ADR. Way back in the Vedic age, you had special groups like the Kula for family disputes and the Shreni for business arguments. For centuries, the village panchayat was the heart of local justice, focusing on keeping the community in harmony, not just on legal technicalities. It actually wasn't until 1996 that these ancient ideas were finally formalized in a modern law, the Arbitration and Conciliation Act.
Okay, so we've seen the problems with the court system, and we know that ADR has these deep historical roots. So what is it exactly that makes it such a powerful alternative for us today?
It really comes down to the tangible, real-world benefits. These are the things that are actively pulling people and businesses away from the old, slow courtroom process and toward these alternative methods.
ADR hits the biggest problems of the court system head-on. First, it's faster, way faster. It's also cheaper. A lot cheaper. Plus, it's incredibly flexible. The two sides can agree on the rules, the location, even the timing. The whole thing is kept private and confidential, which is a huge deal for businesses trying to protect their reputations. And maybe the best part? For complicated disputes, say about construction, you can choose an expert engineer to decide the case, not just a judge who may not know the technical details.
So this all sounds pretty good in theory, right? But to make it more concrete, let's zoom in on arbitration. It's one of the most popular forms of ADR, and we'll walk through how it actually works step by step.
Everything, and I mean everything, starts with this, an arbitration agreement. Usually, it's just a clause tucked inside a contract. All it says is that if a dispute ever comes up between the two parties, they agree right then and there to go to arbitration instead of suing each other in court. This little agreement is the key that unlocks the entire process.
Once you have that agreement, the process is actually pretty straightforward. One side sends a notice saying, hey, we have a problem. Then, and this is so important, both sides get together to pick a neutral arbitrator, that expert who will decide the case. After that, it's a bit like court, but simpler. The claimant files their case, the respondent replies, and they hold some confidential meetings. Finally, the arbitrator makes a final decision, and that's called an award.
And that arbitral award, that's the final piece of the puzzle. Now, it's not just a friendly suggestion. This decision is legally binding. For all practical purposes, it carries the same legal weight as a judgment you'd get from a judge in a formal court of law.
But, and this is a really important difference, a court judgment sets what's called a precedent. That means it can be used to influence how other similar cases are decided in the future. An arbitral award doesn't do that. It only solves the specific problem between those specific people. The arbitrator is totally free to decide the case based on what's fair and just for that one unique situation.
And just to show you how flexible this all is, arbitration isn't a one-size-fits-all deal. You've got different flavors for different situations. Domestic is when everyone involved is in India. International commercial is for when at least one party is from another country. In an ad hoc case, the parties get to make up their own rules as they go. Or they can use institutional arbitration, where a formal organization helps manage the whole process. Sometimes, a specific law might even require you to use arbitration.
And that brings us right back to where we started. We have a modern justice system that's straining under the weight of its own costs, complexity, and delays. And the solution? Well, it might just be looking back to an older, more collaborative tradition. It really leaves us with a fascinating question, doesn't it? Could reviving this ancient way of finding resolution actually be the most innovative step India can take for the future of justice?